Good morning from Seattle, everyone. My name is Tony Varona, and I have the honor of serving as Dean of the Seattle University School of Law. Thank you for joining us for our rapid response webinar on yesterday's Supreme Court decisions in the cases of Students for Fair Admissions versus Harvard College and the University of North Carolina. We have approximately 1,800 registered participants for this webinar, and an all-star lineup of expert speakers from across the United States, bringing a diversity of perspectives and viewpoints and expertise so sophisticated that several of our speakers at today's webinar had their scholarship quoted and cited by the court yesterday. Before I tell you about our proceedings, I wanted to turn over the virtual podium to the president of Seattle University, and I am proud to say a distinguished member of the Seattle University School of Law faculty, who himself has internationally renowned expertise in the subject matter of today's webinar, President Eduardo Peñalver. Eduardo.
Thanks, Tony. Good morning, everyone. Thank you all for being here for this important and timely discussion. Special thanks to all of our distinguished panelists for agreeing to share their expertise with us and insights. And finally, I'm grateful to Dean Varona and the Seattle University Law School faculty and all the staff who planned this innovative rapid response program, not ever knowing exactly when it would happen. At Seattle University, our mission is to empower leaders for a just and humane world. And in addition to an unwavering commitment to academic excellence, this mission requires us to foster an inclusive community that fully reflects the rich diversity of the globally interconnected world that our students will lead toward greater justice and humanity. Our commitment to diversity is ultimately rooted in our Jesuit and Catholic values, and because of that, Seattle University will continue to use every tool consistent with the law and with our values to create and sustain a diverse and inclusive academic community. But discerning what is consistent with the law in light of yesterday's decision, which unsettled decades of complex precedent, is no simple task. And helping us do that is one of the important goals of today's program. Seattle University's foundation in the Jesuit educational tradition adds an important dimension to this process of discerning the path forward. The court's decision yesterday, along with its decision in 303 Creative this morning, leaves unanswered important and complex questions about how its restrictions on the consideration of race and admissions interact with our constitutional right to the free exercise and expression of our Jesuit Catholic values. We're carefully weighing these and other questions as we attempt to understand the legal landscape of our own admissions practices. We hope that today's panels will help us gain further insight on that front, and we hope that this program will serve as a valuable resource for other universities as they grapple with similar questions within their own distinctive contexts and sets of institutional commitments. Finally, we understand that there's a range of opinions on the court's decision yesterday among people of goodwill, including among people who care deeply about diversity and racial equity, and including among members of the extended Seattle University community. An important part of being an inclusive academic community is welcoming that diversity of viewpoints and embracing the rich and challenging and ultimately educational conversations that come from informed and thoughtful disagreement, especially on a university campus. In that spirit, today's program includes participants with a range of views on the issue of affirmative action and on the court's decision yesterday. And we value that diversity of perspectives and look forward to learning from it. So once again, thank you all for being here, and I hope you all enjoy the program, and I will now turn things back over to Tony.
Thank you very much, President Peñalver. As President Peñalver noted, the purpose of today's webinar is to provide a national space for reasoned analysis, reflection, and conversation on the Supreme Court's handling of affirmative action yesterday in the context of other cases. We are proud at Seattle University School of Law of being the most diverse law school in the Pacific Northwest with a Jesuit Catholic mission that makes our commitment to diversity and access a moral, ethical, and non-negotiable imperative. We also enjoy a rich intellectual life at our law school that is fueled by a faculty known for its innovative and path-breaking scholarship that very recently was rated as the most academically impactful of any law school in the entire Pacific Northwest, the most impactful faculty of any Jesuit Catholic law school in the American West, and in the top 50 of all law schools nationally. It is no wonder then that at our Seattle U Law community, we care very much about inclusive excellence in legal education, so much so that we organized today's webinar. Yesterday's Supreme Court decisions on affirmative action answered some questions, but begged many others. Affirmative action itself is a complicated concept. In reading yesterday's opinions, all 237 pages of them, in fact, I was reminded of a speech that the late Judge Constance Baker Motley delivered in 1996 around the 100th anniversary of Plessy versus Ferguson, that looking back from today proved to be very prescient. Speaking of the forms and vectors of affirmative action and its beneficiaries, she said, quote, "The problem is that the issue of affirmative action is extremely complex because it appears in many different forms and in many different contexts," unquote. In that same speech, she said something that might provide us with helpful framing or a backdrop for today's discussions. She said, quote, "It is important to recall the history of the struggle for civil rights for Blacks in this country, because it must inform the current search for equality between whites and all people of color, a struggle which causes great anguish and which threatens our social fabric once again," unquote. Today's webinar addresses what the Supreme Court did to affirmative action yesterday, how and why, and then how higher educational institutions that care very deeply about inclusive excellence, diversity, and access should go forward in a manner that honors the law, of course, but also their missions. Those two organizing questions are the foci of our two roundtables today. I thank our moderators, Deans Deborah Ahrens and Stephen Bender, and our 14 illustrious roundtable discussants who will address these questions in turn. You will see that some of our roundtable discussants will be joining at various times throughout the two roundtables. A few of our webinar speakers, in fact, will be appearing in broadcast media discussing the Supreme Court's decisions in affirmative action and in other areas this morning and afternoon, and so will be joining us for as long as their schedules allow. I give my deepest thanks to the colleagues who made today's webinar possible and ensured its success, including Colin Watrin, David Sandler, Emily Fikes, Julie Brady, Gabby Harrington, Marisa Leach, Tara Lee, and Lincoln Vanderveen. I thank our organizational partner, the American Bar Association, for helping publicize this webinar. Finally, I thank all of our attendees. There will be at least 1,800 of you from across the nation by webinar's end. We want to hear from you throughout the webinar too, so please share your questions and comments with the moderators and co-hosts throughout the Zoom or through the Zoom Q&A feature throughout our webinar. We will be sure to incorporate many of your questions and comments throughout the two roundtables. At the conclusion of the two roundtables, we will hear closing remarks from my dear colleague, Natasha Martin, our Vice President for Diversity and Inclusion at Seattle University, who also is a professor of law here at the law school. With that, thank you, everyone, for joining us, and have a great webinar.
All right, well, good morning or afternoon, depending on your time zone. I'm Deborah Ahrens, and I'm very thankful to be able to moderate this panel this morning, as well as our dean mentioned, very thankful to both the support staff and to our panelists for turning this around on a date uncertain and for taking the time, just for illustration, double-sided, to digest this very lengthy opinion, set of concurrences, and dissents for today. The panel that I'm going to be moderating here has the very difficult and heavy lifting task of trying to make sense of these more than 200 pages of text and trying to explain what the Supreme Court here did and why, some of the history and some of what the justices were trying to accomplish here. And then our next panel will try to figure out what this means for the future. In the interest of time, I want to make sure that we leave our focus on our participants. And so I'm just going to offer each of them the briefest of introductions. Just assume, as is true, that if I were to offer the lengthy introduction each one of these luminaries deserves, every single one of them, you would hear about their expertise and extensive writing in constitutional law and or race in the law, and or specifically their extensive publication and speaking engagements around the topic of affirmative action. Many of them have lengthy and accomplished histories in litigation and leadership around these issues. And so today, our list of panelists includes, in alphabetical order, Dean Michele Alexandre, who is Dean and Professor of Law at Loyola University, Chicago, Associate Professor Jeremiah Chin, who currently is visiting at Boston University, but as of tomorrow, I'm excited to say, will be joining our faculty here at Seattle University. We have Professor Leah Epperson of American University, who also happens to be the former direction of the Education and Policy Group at the NAACP's Legal Defense and Educational Fund. We have Danieli Evans, who is one of our own distinguished assistant professors here at Seattle University School of Law. Richard Thompson Ford, a professor of law at Stanford University. Dean and Professor Dana Matthews, who is joining us from George Washington School of Law. And Ilya Soman, who is a professor of law at George Mason University, as well as a chair in constitutional studies at the Cato Institute. So what I've asked each of our panelists to do today is to start out by offering us around 5 to 7 minutes of their own observations about what the Supreme Court did yesterday. And so we'll be hearing from each of them in turn, mostly in alphabetical order, but as our dean mentioned, there's some reasons that we will be moving panelists around. And then after that, hopefully we'll have ample time for me and for you as audience members to be able to ask some more focused or follow-up questions of our wonderful panelists. So I actually, Dean Matthew had suggested that we would benefit from having her go first. And so, or early, perhaps you didn't say first specifically.
I certainly did not say first.
But would it be okay if I were to throw this to you, and when you're done, I will go ahead and throw it to our next panelist.
Sure. I just want to really be clear that I asked for the early spot because of a scheduling conflict, not because I thought anybody would benefit from me going first. This is an illustrious panel. I am honored to be on it and really thankful to Dean Varona, to Professor Ahrens, and all of the ABA folks that put this together. It's an important conversation and, of course, an evolving one as this decision just came down. So I'm going to start by reading a few headlines from today's major papers, because I think that should inform some of what we talk about. So this morning's Washington Post headline was "Race-Linked Admissions Struck Down." The New York Times was "Justices Rule Against Affirmative Action." The Wall Street Journal, "Supreme Court Strikes Down Affirmative Action in College Admissions." With a little bit more nuance on the West Coast, the Los Angeles Times paper said justices reject race-based admissions, court restricts university policies, but leaves room for diversity. And the reason I read those is because the general conversation is being formed right now, and I would encourage us, as we're diving into the interstices of the opinion, to be aware of what people are saying and thinking about these decisions in this affirmative action case. I contend that they've got it wrong. I don't think that it is a surprise to anyone on this call, but I want to be clear that the takeaways I have been asking my community to recognize from this report are four. One, it is absolutely clear that the Chief Justice and the 5 justices that joined his opinion have removed from any consideration, the notion that educational benefits of student diversity is any longer a compelling interest that will pass scrutiny for the purposes of using race-sensitive or race-based admissions. No question, the educational benefits argument is dead. And he gave us a lot of reasons for it. He said we can't measure it, we can't quantify it. And he was careful to make sure that he eliminated any notion that we should think that the benefits of a pluralistic society, of training leaders, of innovation, of fostering any kind of engagement and productive citizenry, enhancing appreciation and respect for cross-racial understanding. Don't bother. He can't count those. He's not interested in you telling him that those are justifiable reasons under the new strict scrutiny standard. Number two, the reasons that he gave were fivefold, that educational benefits no longer work, that big sea change. Number one, he said, there's no meaningful connection between the means employed and the goals pursued. Number two, he said, you can't use stereotyping. We definitely do not want, and this is an important distinction, we definitely do not want anybody coming and telling us that the Constitution allows you to tell us that the membership in a group, whether it's a racial group, an ethnic group, is enough to ensure that you're going to get diversity. Why? Because all members of a group don't think alike, because all members of the group can't be stereotyped. And that was the thinking and the reasoning behind his second elimination of educational benefits as a compelling interest. Third, he said, you can't use race as a negative harm to non-minorities. Don't harm the white people, right? Make sure that there is not a one-to-one transactional view. I want to make clear that he and the majority have taken a one-to-one transactional view that admissions is a zero-sum game. If you admit one person, you eliminate another person. And so if you are using a standard that is going to harm the people who are not benefited by the race-conscious admissions policy, it is impermissible. And I think perhaps most impactful, number four, you must have an endpoint. This 25-year standard has been elevated. The idea that we're 20 years in with no end in sight was it's extremely important to the Chief Justice and those that joined him. Now, another thing I found, lastly, that was fascinating was his attempt to narrow the period over which this precedent has been in place by saying that the Powell decision in Bakke was a decision for one justice alone. He was able to move the timeline for how long this precedent has been standing. Now, we of course know that since 1978, we have seen the court repeatedly affirm educational benefits as a compelling interest. But according to this reasoning that has been advanced, now we can see that the court said we only adopted the Powell opinion in Bakke in 2003 in Grutter. So now we're overturning a 20-year as opposed to a 45-year precedent. Okay, those things done. What did he leave? Well, the last two paragraphs, of course, at the end of the part 6 of the majority's opinion said, at the same time, as all parties agreed, nothing in the opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. Well, we'll be litigating those words for quite a long time. What they mean in some ways was suggested by two examples. He said if that individual student wanted to say what race had done to inspire them to take a leadership position, to attain a goal, that could be relevant. So some have suggested that reading essays differently will do the trick. I don't think so. I think, and then now I'm going to go to my third point, I think that we should pay a lot of attention to the measurability and quantified standards that the Chief Justice and his 5 associate justices gave us. He told us that he needed to be able to measure, to quantify, in order to understand the impact and the nexus between a race-conscious admission program and outcomes. This is a really important point because many people will stop collecting data And I think this decision tells us to do the opposite. Many people think that affirmative action is dead. I think this decision tells us it's severely narrowed. Make no mistake about it, I am disappointed, deeply disappointed in this decision, but I am not of the mind that affirmative action is dead. I think it is a new day in terms of what we do with it. My fourth of 5 points that I'd like to leave on the table for discussion. I think it's important that Justice Thomas wrote alone. Why do I think that's important? Because his view, in my understanding of the opinions, dissents, and concurrences, and I have to confess, 237 pages, I'm not quite done. So I'm telling you what I've read so far, and they raise these questions so far. Justice Thomas's dissent is, in my view, the most extreme one. It is the one that describes what he terms, in his words, the originalist defense of a colorblind constitution. Note that the colorblind constitution did not play a preeminent role in the Chief Justice's majority opinion. It showed up, and it certainly showed up in the oft-quoted and I think misquoted citation from the Justice Harlan dissent, where he is lauded for being the colorblind champion of colorblindness in the Constitution. Well, of course, Justice Ketanji Brown Jackson and Justice Sotomayor, who gets my prize for the most amazing come out swinging girl from the Bronx. I'm from the Bronx. I have to put in a word for that opinion of those that I've read so far, said, let me tell you about the history of the 14th Amendment, the history of the 13th Amendment, the history of the Constitution. It is entirely race conscious. And the notion that color blindness characterizes our Constitution is an ahistorical notion. She really focused, both Justices Jackson and Sotomayor focused on the ahistoricity, if you will, of this notion of a colorblind Constitution. And they did so with a great deal of power and a great deal of force. The fact that no one joined Justice Thomas in his argument that the use of race in higher education admissions decisions, regardless of whether it helps or hurts, violates the 14th Amendment, significant. He writes separately to share an originalist defense. Well, I count 6 originalists on the court. None of them saw fit to join his opinion. He wanted to clarify that affirmative action is not permitted under the Constitution. Nobody agreed. And he wanted to explain the flaws in Grutter. Why? Because Grutter's not dead. He wouldn't have used his ink if he thought it was. So I'll stop there, and thank you very much for calling on me early and first.
I do aim to please. Thank you so much for sharing that. From here, I'm going to go to Dean Alexandre and ask you to share the thoughts that you'd prepared for today.
Thank you, and thank you to Dean Matthew for setting this up wonderfully. I want to just highlight a few things. One is the jarring contrast between the majority opinion and concurring opinions and the dissents in their interpretation of the 14th Amendment's mandate to implement everything under the mandate of equality. And I think this is jarring because it is there's no middle ground in these opinions. The majority argue that, and I think even though the word colorblind was not used, that the intent was to remove any consideration of race, and that any consideration of race signals stereotyping, etc. And reading the opinion, I was struck as to how some of that analysis was not present in that way in the precedent from all the desegregation cases from Brown versus Board of Ed. So it was fascinating. And then looking at the dissent and really the pointed, wonderful job that Justice Sotomayor particularly does in linking the 14th Amendment equality mandate to educational opportunity, and that there cannot be any equality without access to educational opportunity. And she goes on to say that educational opportunity rectifies the uneven relationship between master and slave. And I think that is powerful. So I say that is a contrast because it reflects the times. We've always been wrestling with with the meaning of a legacy post-slavery and and how this country and our interpretation on what our role is in this country to pursue equality. But this is really us at our most divided in this opinion. So that is my first point. And secondly, I then went on, because remember, this is the second day of us feeling this opinion. So I'm still live reacting to this. So I went on to then really muse on the importance of dicta and how a sentence that is a afterthought, happenstance, amusing, can actually become law. And this is I hope that in 25 years, we will no longer need these kind of policies. And we know, all of us know, that Justice O'Connor has gone on to regret that sentence, but in the majority opinion, it becomes central. And so one of my sources of hope, because I promised that there is a hopeful take also here, is also that dissents make law. So I am really holding on to everything that we saw in the dissent, because I do agree with Dean Matthew that combining the drastic interpretation of what is 14th Amendment, what the meaning of the 14th Amendment mandate for equality is, and of course, Title VI is similar mandate, and seeing how completely different and non-negotiable, right? No compromise between the two, that could be give cause for despair. But we do know that great dissents make great future laws. So then my third point is about looking at then the crux of what is being done in this case. It strikes down the diversity rationale, right? It's no longer a compelling interest. It completely obliterates deference to the institutions, to higher ed, which is just mind-boggling, because deference was such a collection of data and showing a relationship and being able to do that. And then to have the courts say, we don't believe you, we can't trust you, right? We are in another world. But the question that left me with is as follows. What is the difference between higher education, where the compelling interest for diversity has been completely eliminated, and the sector where that is still good law, and that is the military context? In the military context, the case, the opinion from yesterday does not apply yet. So we should ask ourselves, what makes the military context, and arguably one argument is that the need for national security makes the use of race compelling. So what makes that more compelling, and how is that context more trustworthy and more deserving of deference, being that the court has refrained from extending its opinion there? And I think that gives us food for thought. And then lastly, in the opinion itself, we have the silver lining that many have talked about, and this is where I really join Dean Matthew here. It is important to talk about this case. I know it takes longer to do that in terms of nuance and not in terms of headlines. And I disagree with the headlines that say that this has been obliterated. It puts us in a new day. It definitely, we disagree with the interpretation of the 14th Amendment here, but we've been doing that for a while. But the new day is, the court tells us that race it doesn't go away, because this is our country, right? They're not so far as saying that this country is different. We can look at applicants and the adversity that they have overcome, possibly because of their race, and look at those narratives and look at the contribution that they're making to the institution. And as long as race is not the determining factor, is not a factor in our decision-making, those narratives then can inform us as to their belonging. And so that makes me just kind of like, Souls of Black Folks came to mind, right? Who belongs, the talented 10th. And how hard does your life have to be, and how overperforming do you have to be in order to make that cut? And Justice Ketanji Brown had raised that very question during a whole argument when she asked, what about the applicant that's multi-generational versus the applicant that is first generation? And how do we then allow those narratives versus not? And so I'm lost with the question. How do we make this distinction as to who belong? And how hard does that have to be for these applicants for us to say yes? And what's the basis? So that will need to be fleshed out as well. But I found that fascinating because it is a conversation that is happening nationally, right? Because those questions are not applied to everybody. But for applicants where race is anywhere in the perceived, right? I will say perceived, right? For people who are looked at as being in the conversation as a race person. So whether you call that people of color, et cetera, the reality is that it seems that question about, hey, how do you get to be here? Can you prove that you belong? And do we ask that same question of any other group or any other characteristic? And so lastly, I will end by saying, with all of that, I still think there is kind of like a moment here that placed us in the transformative time that we're living in. We always knew this day was going to come. We always wish it would be different. The beginning and the inception of our country was always based on such fragile give and take. But I do think this moment calls for us to be creative and to think about all of the things that were missing with the former standard and how limited we were in achieving true meaningful inclusion in our sectors. And so the call that I'm making is for us to think about how we can go back and think about collaborating so that we start implementing meaningful education opportunity from K to 12. And we'll need to band forces to do that. And we'll need to ask those questions and debunk our own stereotypes as to who belong and not be trapped into the four corners of the limitations that have been given to us. Thank you.
Thank you so much. I'm going to now throw this to Professor Chin.
Thank you. I'm very honored to be here with scholars and thinkers that I admire deeply and to hear the thoughts of some of my favorite deans on the call before I get to move on to my points. And so I think my points are a little more doctrinal, thinking about the ways in which the Roberts opinion completely avoids missteps and outright launders the ways in which the affirmative action jurisprudence has developed over the years. First of all, in any case before a federal court, we are always looking for standing. We need an Article 3 injury in fact to bring a case before the court, and the Roberts Court addresses it very briefly and brushes over this. Understanding we've established in the court's litany of jurisprudence that you need injury, causation, and redressability. What is the injury of affirmative action? That question is never clearly answered by the court, and the closest we get is the zero-sum nature of admissions on page 27, where Justice Roberts says, a benefit provided to some applicants but not to others necessarily advantages the former group at the expense of the latter. It is such a broad and sweeping statement of injury that is never clearly articulated by any of the litigants in this case that it's a little absurd. This kind of broad standing reading now has, I think, potentially opened us to all kinds of claims against elite institutions, particularly ones like Harvard or Georgetown, who have been well-documented beneficiaries of the slave trade, both in the buying and selling of human beings to fund their institutions, and in those legacy admissions who are beneficiaries of the wealth of their generational ancestors. So they have a benefit that was not provided to everyone. Does this mean that we all now have standing to sue these institutions of higher education simply because we did not get admitted? It's a ridiculously absurd position that the Chief Justice is proposing for the injury, but then we also have no discussion of causation. We have no sign that but for their race, they would have been admitted. The court simply assumes this. Justice Gorsuch, in his concurrence, joined only by Justice Thomas, is the only one to come near this, and he's only addressing it under Title VI, which says that on the grounds of race, which he interprets as because of or a but-for causal link. But there is no but-for causal link clearly addressed. Simply the existence of the consideration of race is enough. Justice Gorsuch articulates it as that there may be, no one can doubt that both schools intentionally treat some applicants worse than others, at least in part because of their race, with no citation, no evidence, no discussion from the briefs, simply a generalized statement and assertion. This is in deep contrast to the wonderfully articulated, beautifully well-researched dissents that cite not only bounties of legal history, but incredible amounts of educational and sociological literature on the salience of race to both admissions, educational learning environments, and practice. So even on a doctrinal level, this opinion is sorely lacking in what we would expect of a court that might see to make itself legitimate or take itself seriously in the broader sense of what this opinion actually means. And it is so dead set on this termination of affirmative action, as Dean Matthew and Dean Alexandre articulated before. The second point I want to make is about that endpoint, right? Not only is it blowing up this one line of Justice O'Connor into an entire jurisprudence of race, but it's waffling with the statistics in a way that the court has been very comfortable in ignoring before. Justice Roberts, in particular, just a couple of years ago in a case called Rucho versus Common Cause, which dealt with partisan gerrymandering, said, hey, there's no judicially manageable standard to determine whether or not partisan gerrymandering exists, so we won't even address it, and we're going to kick it back to states and state courts to address. He was very comfortable that the lack of statistical certainty was just something the court couldn't address and therefore couldn't even decide the issue. Here, on the other hand, he's very comfortable deciding the issue because he lacks statistical certainty, the exact opposite of the position he took in Rucho versus Common Cause, and even then a far cry from his opinion years ago in Shelby County versus Holder, in which Justice Roberts says that, well, because we had high turnout in the 2008 elections on the basis of race, therefore we can say the Voting Rights Act is no longer necessary. What could have happened in 2008 that caused a high racial turnout in voting? It very, very well could be the chance to elect the very first Black president, but Justice Roberts completely ignores that data and ignores that statistic yet again. So his waffling and ignorance of the statistics in the opinion of the court in this case is not baffling because it comes from a place of ideological certainty in his mission to dismantle affirmative action. And I think is conditional on this final point of the laundering of the colorblindness rhetoric that was eloquently displayed before. Justice Harlan's dissent is so often quoted for the measure that Justice Roberts does in his opinion, where Justice Harlan said that in the eyes of our Constitution is colorblind and neither knows nor tolerates classes among citizens in his dissent in Plessy versus Ferguson. What is never quoted in any of these opinions pronouncing colorblindness is that entire logic is rooted in anti-Chinese sentiment and Justice Harlan's extreme disdain for the Asian American community, who is ironically being touted as the primarily aggrieved class in this case. Immediately preceding the quote of colorblindness by Justice Harlan in Plessy versus Ferguson dissent is, quote, "The white race deems itself to be the dominant race in this country, and so it is in prestige, in achievements, and in education, in wealth, and in power. So I doubt not it will continue to be for all time if it remains true to its great heritage and holds fast to the principles of constitutional liberty. But in the eyes of the law, there is no a class in this country superior, dominant, or ruling class of citizens." So it's not only a colorblindness opinion rooted in white supremacy, but immediately followed by his anti-Chinese sentiment, quote, "There is a race so different from our own that we do not permit those belonging them to become citizens of the United States. Persons belonging to it are, with few exceptions, absolutely excluded from our country. I allude to the Chinese race." He then proceeds to say the chief injustice of segregation is the fact that Chinese persons can ride in the car with whites and Black people cannot. So this colorblind rhetoric that is being espoused both by the majority and by Justice Thomas's sole concurrence is entirely rooted in both white supremacy and anti-Asian sentiment, but being touted as the iconic symbol of what our nation aspires to be, in a case in which Asian American plaintiffs are claiming they were excluded on the basis of race. This is not just dripping with enough irony to manufacture entire, houses and homes from, but it is a glaring intentional contradiction that the court exploits in a rhetoric of colorblindness in order to devastate, or attempt to devastate, I should say, these programs that are not only beneficial, but useful and so well articulated in the dissent. Again, The harm of affirmative action is never articulated in the opinion, other than this vague idea that someone might get a benefit. So then what are people entitled to? Are these students claiming that they are entitled to an education at Harvard, at UNC, that this is a right that was vested in them by some virtue that they are now being excluded from? Or are they saying, as Justice Thomas's concurring opinion goes at lengths to say, that there's some meritocratic system? There's no clear opinion because this contradiction is deeply intentional, it is purposeful, and it is about missing the key presence of white supremacy and anti-Asian sentiment that motivates these anti-affirmative action opinions.
Thank you. So next on our alphabetical queue, Professor Epperson.
Hello, and thank you. Sorry, I was just sort of digesting your great comments, Jeremiah, and feeling a little bit, to be perfectly honest, a little bit exhausted in some ways, because 20 years ago, I was, busy litigating Grutter and writing about this and talking about this and counseling universities about this. And so I would agree with everything that Jeremiah said. This is, for better or worse, the doctrinal points that you make have been issues that we have faced in this area over the last, at least, since I've been working on these issues for more than 20 years. And it's funny because I often tell my students that when I teach constitutional law, that the stories of our Constitution and our jurisprudence are told by those in power. And we need to understand that full picture, that history is key to debates on affirmative action, and the history of what is the continuing legacy of enslavement and its after effects, particularly in the field of education. And so I think I was just reminded of that, Jeremiah, when you were giving a wonderful sort of doctrinal summary of what we see in this area. So I think I don't want to repeat with SFFA, and how does this comport with the fact that we all agree that there is 45 years of 45 years of precedent that has gone away in some way. I think it is important to highlight that the court has held that diversity is irrefutably important. So, if we're thinking about these key points, this goes back to Dean Matthews saying they've not overturned affirmative action. What we know is that diversity is irrefutably important, that students can and must still share their experiences and their stories related to race. This decision does not extend, also, we all know, past college admissions. But it's not, in terms of arguing the point of the importance of diversity, that is a part of the majority opinion. They don't deny it's important. They just say, we have no competency to measure how to determine whether we get to that, to get to the goal that we seek. So I think that is important. It's also important, and this kind of goes to what Jeremiah was talking about, what happens with the imposition of color blindness. And we've seen this, again, in some way, shape, or form for decades. But in this opinion, this imposition of color blindness by the court actually takes away the tools that we have historically used to reach these goals on which we all agree. And that is the difficult piece for us right now. We have great discussions by the dissenters and in opinions going back, talking about the role of the greater appreciation for an understanding of civic virtue and democratic values, and quite frankly, decades of research on this as well. So if they wanted to look to that, there's tons of social science research that does support this. But when they impose the notion of color blindness, it does make it far more difficult to use the tools that colleges and universities have used over the years to seek to achieve diversity. And certainly this is part of, as some may have said, a concerted, well-funded effort to suppress diverse perspectives and to limit educational experiences. And we've seen that in those states that have actually outlawed affirmative action in the last number of years. I think that the other point I would make about color blindness is that for those of us who are well-versed in this area through our work and our scholarship and our practice, that this does completely distort the promise of Brown. And that's what we get in Chief Justice Roberts' opinion. We know that Justice Marshall absolutely was not using a colorblind principle. It was about breaking the back of legal apartheid in the United States. That's what that opinion did. And the reality is that systems of entrenched white supremacy continued for several decades. We know that there were 10 years where 98% of the schools in the South remained entirely racially segregated. So we're not talking about this magic bullet of Brown suddenly changing the United States to become a sort of kumbaya moment. We also know that through white flight and demographic shifts and other Supreme Court opinions, we have elementary and secondary schools that remain deeply racially segregated. And so we have to kind of keep all of that in mind when we're looking at how we address efforts to achieve diversity going forward. The majority kind of uses the point of Brown in a very special way, I would say, but a complete misrepresentation of the promise of equal educational opportunity that was at the heart of the decision, and a movement for racial equality. It's not about what's on a piece of paper. It's about what our schools look like and what the doors of opportunity mean for those who are trying to go through them. And it's funny because in Jeremiah's quoting of various Supreme Court decisions, it actually makes me think of the parents involved in community schools versus Seattle decision, which is not higher ed, but K-12. But Justice Breyer, in his dissenting opinion, kind of makes all of this clear all those years ago about the promise that's embodied in what he called the 3 amendments that are designed to make citizens of slaves. So understanding what the meaning and the purpose and the foundation is of the Reconstruction Amendments that were founded in the wake of enslavement. And it was about true racial equality that's not a sort of pithy little statement that a Chief Justice may make, but a matter of everyday life in America's cities and America's schools. And it was about the nature of our democracy that has to work for all Americans. I believe that that is actually still in the interest of everyone, something that the majority of Americans want to work toward. And so I think it's important to keep that in mind when people are lamenting the significant narrowing of opportunities for diversifying colleges and universities that we see with the majority opinion. And so in that sense, I think it is important, and I know that we will have a second roundtable to talk about this, but to really focus on the moral and legal imperatives that colleges and universities have to ensure that pathways are open to all students, that students can still seek to share their whole experiences, including their racial experiences, and that is incumbent upon us at colleges and universities, quite frankly, incumbent upon everyone. This is not limited to admissions, although the decision was limited to admissions, to be bold and aggressive about that. And that can happen in a number of ways, but it is important to look at the statutes and constitutional provisions that exist, the very ones that were used to limit race consciousness today, forbid not only state-sponsored racial segregation, but they have a duty to advance substantive equality. And I think we can look at that with the 14th Amendment. We look at that with Title VI in how practices may continue to disadvantage students both at K-12 and in higher ed, and use those to address what we can do in the future with respect to partnerships, to pipeline, to recruitment, to DEI efforts that extend far beyond the specific education domain and go into employment. And as I mentioned, particularly looking at K-12, sort of underrepresented communities in which we recruit K-12, community colleges, transfer policies, all of those kinds of things. I think it is very important to, and this kind of goes back to what Dean Matthews was saying, to not sound the death knell. And we're getting a lot of that in the court of public opinion. I was just looking quickly at the comments. I know we're going to have time to talk about them, but there was a comment about what do non-lawyers do? And I think all of this is about opportunities for people who don't have a JD to continue to hone in on the importance of seeking this expansion of opportunity in any way we can. The final point I'll make, and this was true 20 years ago, although it came out more quickly this time, I think we all heard President Biden's comments yesterday regarding the decision. And I think that there is a key role that the Department of Education, the Department of Justice Office for Civil Rights both play in sharing information and best practices And that has historically been a role that they play that is a sort of boots on the ground, helpful way to bring together educational institutions to ensure that their policies and practices are lawful, but are also focused on the higher goal of seeking to ensure that these pathways of educational opportunity are open to all students. I'll stop there and hopefully we'll have plenty of time for a Q&A discussion.
Thank you so much. So we'll next hear from Professor Evans.
Hi, so I am also really honored to be a part of this panel and admire everybody on it. So thank you all for having me. I'll try to keep my remarks pretty short because I like to leave as much time as possible for questions. And so the first thing I just want to say is I've been reflecting, since the opinion came out yesterday on the significance of it. And the thing I keep coming back to is separating the practical impact from the expressive impact. And, we're talking a lot about what is the practical impact of this decision. And there are these caveats where you can still write about race as part of your experience in an essay. And maybe there are ways that we can use that and other targeted recruiting mechanisms and various other things to achieve the same amount of diversity or better amounts of diversity. And I know the next panel will talk about that. But even if that's true, there's this second, and I think very significant expressive harm here that's worth mentioning and calling out and considering. It's an official pronouncement by the highest court in the country that one, remedying societal discrimination is not a compelling interest. And here I'm encompassing also Bakke and Grutter. And two, that creating an inclusive environment is not a compelling interest. And three, that the harm of equity and inclusion-oriented programs, like the ones at issue here, is equivalent to the harm of de jure segregation. All of that trivializes, demeans, and degrades the harm of de jure segregation and ongoing racial discrimination and structural inequality. And this official pronouncement is significant. It really says something to Dean Alexandre's point and a couple of the other points that came up already about belonging and about whose interests matter, and about the importance with which our high institutions regard issues of racial inequity. And so I think that that's a harm that that expressive harm is a harm that even if we can achieve comparable diversity through other means is one that's very hard to take away. And it's an incredibly important pronouncement about belonging in 2023, as inequities in the race wealth gap and various other forms of racial inequity are widening in the ways that Justice Jackson's dissent pointed out so well. So that's the first point I want to make, is just to think too about the expressive harm here as well as the practical harm. And then the second thing I want to do is say something a little bit more, open up a little bit more a conversation about the compelling interests that could potentially justify race-conscious admissions. The court's opinion is focused very specifically on diversity, and that's the one, if you listen to the oral arguments, that the advocates were advancing. And Justice Roberts, for the reasons that have already been noted, says that there's diversity, this is not a compelling state interest, at least not one the judiciary can evaluate. But I want to think a little bit about what other compelling interests might be justifications for considering race in the way that these schools do, because it strikes me that there are several, and some came up in the dissenting opinions, and the majority opinion really doesn't say much about them or do them justice. The first one that I would like us to think about a little bit is what I'm going to call belonging, and I don't know if this is a way to think about diversity or a different interest, but belonging is, some authors, John Powell and others, have argued sort of the core quality of citizenship, what it means to be a citizen. Education, as we've talked about already, and as the court acknowledged in Brown, is one of the most fundamental elements of preparing people for citizenship. And belonging within an educational institution for all the social science research is a incredibly important predictor of a person's ability to succeed in that environment. And one aspect of belonging is representation, right? So if you don't have people like you on campus, that is going to impact your sense of belonging. So to create an educational environment where people have just an equal opportunity to do well, to succeed, to achieve their potential requires creating an inclusive environment, an environment where people feel like they belong. And when I read the court's opinion, and I would listen to oral argument and the questions about diversity, they don't really get at that belonging dynamic as much. They're more about the instrumental benefits of diversity in terms of workforce and having class discussion with different ideas, all of which are really important. But belonging is so closely linked to a person's ability to thrive and succeed and to become a full and equal participant. And if they can't do that in education, it's going to be harder to do that in society more generally. Another one that I would think we might consider, and this comes up, I think, really well in some of Justice Jackson's questions at oral argument and in the dissent, is mitigating the inherent bias in purportedly meritocratic admissions criteria. The admissions criteria are skewed so heavily in favor of historically dominant social and cultural groups. And that ranges not only from, very obvious things like legacy preferences, but also to all the ways in which capital related to like test taking skills and early childhood education and things like that are passed down between generations, and the ways that, it just gets to the point of the intergenerational privilege in Justice Jackson's dissent, the ways that parents who have learned how to, do well on standardized tests, teach that to their kids, speak to their kids in different ways, using more analogies, and that in turn has an impact on a person's test performance 16 years later. There's research showing all of this. And then to even more, prejudice-oriented ways, like teachers have different expectations and react differently to Black and white students who engage in the same behavior based on cultural stereotypes and stigmas. And all of these ways are criteria for evaluating people and scoring them that are purportedly meritocratic are actually very heavily skewed in favor of whiteness and white privilege. And so one way to think about race-conscious admissions is just doing something to mitigate a set of criteria that have a disparate impact, and one that is not justified, one that is culturally skewed and itself biased. And then a third sort of related interest that I think we might think about is just this one that Justice Powell rejected in Bakke, is remedying societal discrimination. Justice Jackson, I think, very convincingly discusses, like, why is this not a compelling interest under the Equal Protection Clause, which is about racial equality and equal opportunity? Why would ongoing societal discrimination comport with that? And I don't think Justice Powell and Bakke, or the opinion of Croson, which discusses this, or the majority opinion in this case, do a very good job of refuting the idea that remedying societal discrimination is a compelling interest that under the Equal Protection Clause, indeed part of the state's duty under the Equal Protection Clause. And Justice Thomas suggests this can't be a compelling interest because the court would be picking sides as to which group is being subordinated. So we can't do an anti-subordination logic because who's being subordinated depends on which side you're on. But that's just not, there's objective data, like in Justice Jackson's opinion, that show there are status hierarchies in wealth and privilege and opportunity in society. And so why would remedying those hierarchies not be something that is a compelling interest? And so with that, I want to just hoping to just put those things on the table and have us think a little bit more about sort of this narrow focus on diversity, which is super important, but these other possible interests that the court really failed to consider or even give enough attention to given the potential they have, the importance that they have in our society.
All right, thank you so much. At this point, this is the participants that we have as a told you, and as the dean told you, we may have some people who, for scheduling reasons, may be moving around a bit. So what I wanted to do, we have time for questions now, is pick up both on some of what Professor Evans was just saying, as well as one of the questions that we've received from the audience. We had a question from the audience about the implications of this for medical education and what perhaps physicians could do. And when I was thinking about Danieli's presentation just now, and when I had originally read the opinion, one of the things that I personally was really struck by was, on the one hand, Justice Roberts said it's really difficult for us to quantify what value diversity has, right? We can't measure the supposed benefits of affirmative action. But what's kind of left unsaid, and I think several of our panelists have spoken about this, is the idea that merit, on the other hand, is really easy to quantify, right? That if Harvard has as one of its 4 criteria that it might cut potential admittees using would be your status as an athlete, that clearly being someone who can play field hockey very well makes one meritorious for entrance to Harvard. And so one of the things that I wanted maybe our panelists to talk a little bit about, because I was thinking about this in the context of, we know some of the negative health outcomes that, you know, Black pregnant women in particular experience, in part because of the lack of representation among physicians. If our panelists had responses to both, you know, Professor Evans's idea that maybe there are things outside of just diversity, not that diversity isn't enough in and of itself, that can be presented as justifications for affirmative action, responses to Justice Roberts's assumption that that's hard to measure, but it's easy to measure merit. So thoughts our panelists might have about any of that. And I think if, you know, people just want to unmute and speak, we should be fine. If it gets too raucous, I suppose we can move to hand raising.
I'm raising my hand and unmuting my mic. I don't want to be a part of the raucousness. All right, I'll jump in. I think this is a really important point for a number of reasons, and I'm going to use medical education because that was the source of the question. So first, let me say one of the beauties of your comments, Professor Ahrens, is that we can focus in on the measurability, the quantifiability parts of the majority opinion. In medicine, it is very easy to quantify the impacts on health outcomes, health access, on risk assessment of diversity. So the idea that the benefit in medicine is a wonderful way to start the discussion also leads me to point to the experience in California following Proposition 209 with medical school education. So everyone knows Proposition 209 is one of the 9 legislative bans on affirmative action. And immediately following the implementation or the passage of Prop 209 in California, we saw in medical schools a decline, even a plummet of enrollment, particularly of Latino American, and African American enrollees. Before, in 1990, the Prop 209 was passed. There were approximately 119 Latino students. In 1997, following the passage of that act, there were 92. Similarly, with respect to Black enrollees in medical schools in California, we went from over 100 to 47 African Americans in 1996. So between 1990 and 1997, after the passage, immediately after the passage of Prop 209, there was a decline. However, the medical school administration in California went to work looking at ways to improve, and the outcomes you will see if you look at the data are that today in 2019, as of 2019, there are more Latino and more African American medical school enrollees than there were before Prop 209 was passed. Now, this is real important for a number of reasons, not only because the strategies that were used in medical education were important, and I commend those to you. They were not just quote unquote race neutral, they were actually race conscious, if you will. They looked at things, as in Michigan, where there's also a similar cup recovery to look at. They looked at things like zip code, but they also looked at attracting, supporting, mentoring, assigning classes to students based on the needs of underrepresented populations, based on the empirical evidence that there were outcome improvements where racial dyads between physician or provider and patient would produce better outcomes. So I think there are very instructive ways in which we can see, A, that there are strategies that work, apart from the strategies that that have been neutralized, but B also, and I want to hone in on this because I don't think that we should fail to note the importance of keeping data. One of the things that I fear most about this opinion is the spillover effect, right? This is a opinion that is about admission standards in higher education, right? Does it mean we can't collect data? Does it mean that we can't have a course on race? Does it mean we can't have hiring practices that are race conscious? It means none of those things when it is cabined to the formalistic terms, and this court has really been quite formalistic in its application of how it's going to analyze strict scrutiny and racial classifications in higher education. And so I think it's important for us, not only in this early stage, to win the war of public opinion, if you will, not just with respect to whether affirmative action is a dead and alive. It's the Mark Twain thing, greatly exaggerated are the reports of its death, but also what it does mean for the rest of the spillover impacts. There are people who are, I think, highly motivated, well-funded, and very directed at enlarging the meaning of this decision. And I think it's very important for us to strategize not to have that happen. It's important for us to strategize how we will then also not give up on the essential and vital need for diversity in higher education. Now, the last thing I'll say is that the medical environment has that empirical benefit. I think we have the same benefit with respect to access to justice and law. We can talk very quantitatively about the differences between unrepresented and that is per se parties in litigation and represented parties, the racial composition of those representations, who takes those cases, where those practices are going to change, that is practices in admission, are going to change the access to justice, the justice outcomes, if we are diligent now about collecting the data.
And I'll jump in to say that I think that something that's not talked about is the reality of the way admissions are done in most schools. Harvard and UNC perhaps give the impression that every school conducts admissions the same way. And I think part of the education process for the public is for them to understand that we have been very sober-minded about all of this for a long time, and that we do consider applicants holistically and individually. And so to that end, right, this is not a crisis in higher education. So yes, all of the schools will go and look at the what remnants there may be in admissions policies to make sure everything is complied with the opinion. But as Dean Matthew just stated, this is not kind of a death knell that has now immobilized higher education. Instead, it finds us having really anticipated these changes. And then second, to talk about other measures, President Biden's, made a great statement yesterday about the nature of this country and how the opinion belies the current reality of the democratic process and makeup of the country. And I would make a call, right? We can't do this alone. The reality is that our country is wholly unequal educationally. People who are disadvantaged who make it to higher education are the rarity. If you look at the numbers, we have increased, but it's still kind of like, if you're lucky, because the criminal justice system and everything intertwined can cause people to be derailed. So my call is for the government to also implement lawful ways to fund programs that will improve the educational quality of schools so that we can properly collaborate with them. We just cannot talk about this opinion and all of the death knell and all of this without the reality that this is an unequal country. And our kids don't have a fair chance under any circumstances, even when they have all the privileges. So rather than the kind of like hyper active media frenzy, it would be so wonderful if we talked about how then do we commit properly to the school system, and really give props to the higher education for having adjusted recruitment and policies in a way that really considered these cases from a realistic point, and understood that this moment was to come, and that we weren't putting all our eggs in just one tactic.
And I'd want to just chime in really quick, not to keep repeating the same order we did earlier, but I think it's also a call for, especially these elite institutions, to put their money where their mouths are in defending the diversity rhetoric. If we're looking for data, they can assess their campus climate through studies to show that students of color feel uncomfortable on their campus and need additional representation at a faculty, administrative, and student level. And universities know how to collect that data because they have departments of education with wonderful scholars who do this on a regular basis and know how to collect this information. And so once we have universities collecting and asserting that individually, and by individual, I mean organizationally as institutions, there is a need for an increased diversity in the student body, there's about as clear of a demonstration on the court's own standard of what needs to be done, or what kind of practices the universities as administrators and educators can do. The lack of deference the court gives at educational institutions, scholars, and administrators is distressing, but I don't think insurmountable.
Well, and just to wrap this up, I would say Dean Alexandre's point about President Biden's message is an example of a place where, so as not to reinvent the wheel, when you're talking, for example, about Dean Matthews' observations about medical education, the thing that's different in 2023 than when, say, we were discussing these issues in 2003, is that we do have even more information and data about what has happened in places like California and Michigan to try to address all of the ways in which we know racial inequities exist and how to sort of amass the data to open those pathways. So I think there's a real role for, as I mentioned before, places like the Department of Education and DOJ, OCR to bring together information around these best practices so that colleges and universities do not have to start at zero, and so that institutions that have greater access and funding to do the research can actually provide that to those colleges and universities that do not have those resources. Because as Professor Chin said, you can do this at Harvard, you can't do it everywhere. But what we do know to be the case in the United States is that, the rhetoric around meritocracy, we are not a country that admits students in higher education based on a test score and a GPA, period. We have a holistic admissions process, and colleges and universities for decades are aware of the fact that the playing field is not level. Not every applicant comes from the same place. And so it's incumbent upon all of us now to actually pull together resources from those institutions that are more advantaged, and also take advantage of, as Dean Alexandre was mentioning, to take advantage of what our federal government is poised to do right now. And I think given that Biden came out within a couple of hours to make a statement with very clear directives and to say within 45 days, we're coming out with some information because we want to ensure that we are supported. That was one of many things that he said. But just as an example, I think that touches upon the points that Dean Matthew was making in particular about how we share this data and how we can use it for the future.
Professor Evans, did you have anything that you wanted to add? Because we are very short on time at this point, and so I don't think I have time to throw out my question about colorblindness that I think would take more than a minute or so.
No, I'm happy to defer to all the others. Thank you. That's all. Yeah.
Well, and I want to thank the panelists, not only for obviously offering us a really rich and interesting set of presentations and discussion, but for also, and this is difficult for you to see who are out there watching the webinar, as they were answering the questions, really answering the questions that were also appearing over in the Q&A. We had a lot of questions about things like data collection, which I think you have had addressed, about things like legacy emissions, which I think that you've had addressed. So for not only just showing up and on short notice with such thoughtful presentations, but also for addressing the kinds of questions that we all have about this decision. So thank you again for taking the time to digest this opinion and share it with us. And now I'm going to throw this over to Dean Bender so that he can have a conversation with some other wonderful panelists about what exactly this means from a practical perspective for educational institutions.
So thank you, Dean Ahrens. We're moving forward, which is the name of the of our roundtable, our second roundtable. We're moving forward without a break. So stretch in our audience as you're able. And we are talking about moving forward and the response in higher education to the decisions yesterday. And so several of our panelists are going to reconvene here in Seattle in September as part of our EPIC Black Law Student Association Conference Symposium Summit that's going to commemorate a 25th anniversary, not of Justice O'Connor's famous one-liner of the expected sunset of affirmative action programs, but of the SALT Care March, the Communities Affirming Real Equality March in the AALS in San Francisco that some of our panelists took part in, including me, 25 years ago. That was a march around real material equality rather than mere formal legal equality. And that summit's going to be a look ahead to what university admissions can and can't do to foster diversity in the classroom. And they're entering and graduating classes. And we're going to do some of that discussion as we're able in an hour-ish to do today. And so to frame that, let's look at the language of the conflated rulings yesterday for framing and guidance. Start with Justice Sotomayor's dissent. She said the pursuit of racial diversity will go on. Although the court has stripped out almost all uses of race in college admissions, universities can and should continue to use all available tools to meet society's needs for diversity in education. Look also at the majority that said in the opinion, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. But universities may not simply establish through application essays or other means the regime we hold unlawful today. What cannot be done directly cannot be done indirectly. And I would add to that language, the wisdom from Dean Michele Alexandre's imperative today to us to be creative. And so with that, we're going to hear initially from each of our panelists around the question of thinking creatively. I'm going to ask them to speak to the issue of, is student racial diversity still the goal, the value that higher education should pursue? And if so, what available tools in higher education admissions generally, or maybe law schools specifically, remain available to actually deliver that diversity? Is it zip codes? Is it the Texas approach of admitting the top 10% of every state high school student graduating class? Is it a focus on first generation, on economic class, on multilingualism? What about application essays on race, that how it affected the applicant's life, or the applicant's commitment to diversity as a societal value asked in application admissions essays? What can Jesuit or other religious schools with diversity missions do different than other schools? What about considering an applicant's run-ins with the legal justice, the criminal justice system? What about changes in K through 12 education? What about looking beyond admissions to actually nurturing students and their diversity and ensuring they graduate? So put different, This might be sort of what lawful approaches can deliver diversity that's race conscious despite the Supreme Court's colorblind jurisprudence. And as part of that, you're welcome to speak, as we heard in the last panel, to the lessons from the experience of California and Michigan and other states that abolished preferential treatment of race in higher education's admissions. So that's a lot for an, for a framing. But I'm going to turn first to my colleague at Seattle University, Professor Angelique Davis, for her thoughts.
Thank you, Stephen, and thank you for the invitation to join today. So my comments are in the context of my research with Rose Ernst regarding racial gaslighting, which we theorized and defined as the political, social, economic, and cultural process that normalizes the white supremacist reality through pathologizing those who resist. And so while racial gaslighting operates on both micro and macro levels in society, our research has specifically looked at how the judicial branch engages in racial gaslighting through their decisions and how it shapes political and social discourse. And this is particularly important to what you were asking today, because the way we view the world and our place in it, as well as our possibilities, is socially constructed. And just as the Brown versus Board of Education decision opened up a host of possibilities regarding equal opportunities for education and the national narrative regarding equal access to education, the narrative and the framing that was set forth by this court will also have implications for generations to come. So I want to break down some of what happened with the majority opinion in this case and how they attempt to racially gaslight America through the political discourse and what this means and things that I think institutions of higher education can do. Because if you look closely at the case, the court is deciding a hotly contested political issue, not the facts that are actually set before it as required by Article 3, Section 2 of the Constitution. So essentially what I'm saying here is that higher education institutions really need to find ways to interrupt the racial gaslighting narrative of the Supreme Court in this decision that normalizes the white racial hierarchy. And they're going to really need to focus on devising strategies to navigate through this political smog, because racism is not over, even if the Supreme Court says it is. And so there's three ways they can do that. First is to be cognizant of how the Supreme Court normalizes whiteness through its colorblind analysis. Two, be very clear about how this decision impacts all of us, not just the privileged elite. And three, recognize that the court in this decision is triangulating communities of color in order to maintain a white racial hierarchy. So first, in thinking and being cognizant that SCOTUS the Supreme Court is normalizing whiteness through this colorblind analysis, it's really normalizing the white gaze through its blindness to structural racism, right? So what is happening here is worse than a false equivalency. It's valuing a particular lived experience over another, what law professor Brenda Gibson has called a mirror-tocracy. For example, it normalizes and mirrors preferential treatment for white people through legacy admissions, athletics, particularly those at Ivy League schools, such as rowing and lacrosse, golf and tennis, right? Others we can think of. SAT scores, right? Which we know are designed to preference white students and was formed by eugenicist Carl Brigham in the 1920s for the College Board. And then they also have the audacity, Roberts does at the end of the majority opinion, to say that they're going to watch for proxies for race in the admissions process, when all of those that I just talked about are proxies for whiteness. So secondly, it's really important for institutions of higher education and the general public to be very clear how this decision impacts all of us. It's not just the privileged elite, and that there's a moral and historical imperative to address the ongoing legacy of racism in the United States, right? So as I was talking about, as Sotomayor, Justice Jackson, and their dissent talk about how this decision does not take into account the lived experience of most Americans, and that the reality is that it's not just elite institutions like Harvard and UNC, right? It's all of young adults and all people that are seeking higher education in the United States. It also impacts the quality of education and ability to prepare students for the diverse society that we live in. And I think what is particularly noteworthy is the necropolitical impact of allowing race to be considered in admission in military academies, but not in other areas of higher education. And by necropolitical, I'm referring here to the power of government to decide who lives and dies. And here the court is essentially deciding, as noted by Justice Jackson, that we can use race for admissions to military academies. So essentially allowing people of color to be sent to defend and die for this country, but not providing them access to an education that will train them to lead it. Just like what happened to my uncle back in World War I when he was in a segregated, military unit. Third, it's also important for institutions of higher education and the general public to recognize that this court in its decision is triangulating communities of color in order to maintain a white racial hierarchy. So it's promulgating a false narrative about Asian Americans. As was noted, not one Asian American testified in this case as to a harm that they suffered, and it utilizes the model minority stereotype that is not supported by the data. And so it's misleading many into thinking that Asians were not getting into universities and that this was on the basis of race, when the overwhelming data does not support that. And as noted earlier by Professor Jeremiah Chin, Justice Harlan's dissent in Plessy versus Ferguson that's cited by this court for the proposition of colorblindness is rooted in white supremacy and anti-Asian animus. And so essentially what I'm saying here, and there's many other points that I could make later if there's time in Q&A, but institutions of higher education need to be very clear in their messaging, in their narrative, in their focus, and how they're also educating about the historical and ongoing legacy of racism in the United States, and not allow for this focus to be diverted by this white supremacist tactic of racial gaslighting. Thank you.
Thank you, Angelique. Let's hear now from Daria Reutmeyer, who has been at USC and is joining the faculty this moment, probably at the University of Colorado. So congratulations. And she actually foresaw this by writing a piece a few years back about when and if the Supreme Court abolishes race-conscious affirmative action, what then can it ask for from applicants, and what can applicants deliver in terms of their applications?
Thank you so much. Yes, I am in the middle of shifting. Tomorrow, I believe, is my first day, if not Sunday. So let me just say a couple of words in prologue. I do think it is potentially the time to abandon diversity as a goal. I know that's a controversial statement, but it was always a second best option relative to remedying past discrimination. And I want to propose that schools really should shift to remedying past discrimination, and that they do it in a way that does not trigger strict scrutiny. And my proposal is that schools can do so long as they do not use racial identity as a proxy for suffering discrimination, for experiences of discrimination. And remarkably, conservative justices lead the way with regard to this strategy, the strategy that so long as you don't use racial identity to assume that all African Americans or all Latinos and Latinas have suffered discrimination, if you directly measure or evaluate people's experiences with discrimination, that doesn't count as a race-conscious or race-conscious strategy or racial classification. So Justice Scalia writes in Croson that if the state were to identify victims of discrimination and award them jobs, that doesn't violate the Constitution because they are awarded those jobs on the basis of the fact that they have been identified directly as victims of discrimination. And that's true even if all of the recipients of those jobs are Black, and even if the discrimination that they suffered were racial. What Scalia objects to is using racial identity as a proxy in a way that assumes that all African Americans are victims of job discrimination. Justices Kavanaugh and Thomas in the current case also support this idea. Both of them, Kavanaugh in the Q&A and Justice Thomas in his concurrence, identify the idea that when former slaves, formerly enslaved people, were awarded benefits through the Freedmen's Bureau, They were awarded benefits on the basis of their status as former slaves and not on the basis of their racial identity. And Justice Thomas actually says explicitly in the concurrence that that kind of award for benefits was a race-neutral award. So building on that analysis, I propose that schools should ask applicants to identify their experiences with discrimination, and in particular with regard to structural disadvantage, not for diversity purposes, but for the purpose of remedying past discrimination that blocks access to higher education. And so applicants should be asked about whether or not, or should be asked in an open-ended way of to identify their experiences with structural discrimination, but they can be asked in particular whether they've grown up in residentially segregated neighborhoods, have they attended segregated public schools, have their family members been incarcerated, have their parents earned less wealth than in the community because they do not own their own homes. Those kinds of experiences with discrimination, directly or indirectly with regard to the immediate family, would not be race-based under the conservative analysis that I just mentioned. And this would be true even if all successful applicants with such histories were people of color, and even if the discrimination that they identified were explicitly racial. Now, people will object, well, this is unconstitutional because it's intended to classify on the basis of race and to get around the court's prohibitions on such programs. But I argue that it's quite the opposite, that racial identity was used as a shortcut way to identify people who had experienced discrimination in its first iteration. And in fact, these programs that I'm mentioning would bypass the use of race as a proxy in favor of a direct evaluation of an applicant's experiences with discrimination. And so these programs would actually move away from a focus on racial identity and more in the direction that Justices Scalia, Thomas, and Kavanaugh would support. Now, I'm under no illusions that a conservative court would sign off freely and gleefully on such a program, nor do I remain blind to the expense that an institution would incur, both in terms of doing such screening and also in terms of taking the risk with regard to litigation. That said, I do think that it's possible to use the conservative analysis as a way of finding a path forward explicitly for institutions to identify remedying past discrimination and not diversity as the goal, and then asking applicants to directly identify their experiences, specifically with structural disadvantage, as a way of using institutions to move the ball forward in a direction other than diversity. Thanks.
Thank you. And Daria was one of those who took part in the Salt Care March so many years ago in San Francisco. So let's turn now to Vinay Harpalani, who is at the University of New Mexico and is the Lee and Leon Karelitz Chair in Evidence and Procedure. Thank you so much for joining us.
Thank you for having me. Looking forward, I mean, unfortunately, the decisions yesterday against Harvard, UNC, I think are just the first cases that we're going to see that really, I think, challenge the efforts to have racial diversity in higher education, in education generally. There's another set of cases brewing on magnet high school admissions that are also going to affect this whole conversation here. I want to talk about those a little bit also, because I've been thinking about those for a while, even before these decisions came out. They're coming up hand in hand, and they're going to really potentially exacerbate a lot of the challenges that we're going to have, that we're talking about here, that we're trying to remedy. So I think it's important to keep in mind as we move forward everything else that's happening also, because this is kind of part of a broader attack on race consciousness, on efforts to have racial diversity. You think about the attacks on quote unquote critical race theory in education. It's really an attempt to erase race and race consciousness from our society. So just to get into this a little bit, the major case right now is Coalition for Thomas Jefferson, the Fairfax County School Board. And I just want to talk about that a little bit and kind of frame where where that might lead to in the future. So this was about Thomas Jefferson High School for Science and Technology in Fairfax County, Virginia, #1 rated public high school in the country. It's a magnet school with a very selective admissions process, but was very racially skewed in its enrollment. Back in 2000, I believe 2018, 2019, something like 70% of the student body was Asian American. Can't remember the exact numbers of white students, but Black, Latino students very underrepresented. We're talking, single digits, 2%, 3%. And the school board found this to be a problem. The way Thomas Jefferson admissions worked, they had a standardized test. They had a number of different academic criteria in their admissions policy, and it was leading to this kind of skew in racial representation. Asian Americans make up about 7% of the population in Fairfax County, but 70% or so in 2019 at Thomas Jefferson High School. So school board decided to make a change in the admissions policy. Mind you, this is not a race-conscious policy. The policy that was that they had in place did not consider race as a factor like the Harvard and UNC policies did. This is magnet school admissions. So they changed the admissions policy to consider they got rid of the standardized test, made a number of other measures, in terms of changes to the academic criteria, which classes students take, but also made some changes to include geographic diversity, that certain percentages of students from different middle schools had to be admitted under the new policy. So they, used the new policy. It did have an effect. It did increase the number of Black and Latino students. Was a drop in the number of Asian American students from about 70% to about 50 something. So, a significant drop, but still much, much greater than the population in Fairfax County. So this was challenged. Pacific Legal Foundation, got together with some Asian American parents who were not happy about this. And this case is different from the Harvard case also. Number one, there's no explicit use of race here. As I said, both the old and new policies did not use race. The change in the policy was intended to increase racial diversity. And that's a key there, right? Because all these efforts that we're talking about that universities could use, we want more racial diversity. Maybe we can't use race, but using the zip codes, using socioeconomic status, using other proxies, there's still a purpose there that we want more racial diversity. And that was the reason for the change in the Thomas Jefferson policy. We want more racial diversity. This happened in the summer of 2020 when there were Black Lives Matter protests going on. That was part of the discourse. So school board changes the policy. It's challenged. The change in the policy is challenged. The claim is that there was a racial purpose here. It was motivated with animus against Asian Americans, motivated to have a particular racial composition. District courts agreed with the plaintiffs, actually, struck down the new admissions policy, which created more diversity. Fourth Circuit stayed that ruling, and allowed the new policy, the pro-diversity policy, to stay in place, even though the district court had said, it should be struck down. Supreme Court did not lift that stay. So that was one kind of positive moment in there when we were looking at what's going on here. They allowed the new pro-diversity policy to stay in place. And the Fourth Circuit reversed the district court. So the new policy is in place, but this case could well go to the Supreme Court. And again, what this case is about is not about race-conscious admissions, which the Harvard and UNC cases were about. This is race-neutral admissions that is intended to increase racial diversity. That's also being challenged right now. So, I hate to pour fuel on the fire and come from, that negative of perspective, although, we had the decisions yesterday. But any efforts to increase racial diversity, in education, because this is, as I said, this is magnet high school admissions case, but you can bet if the Supreme Court rules on it, it's going to have implications for higher education also. Any efforts to increase racial diversity have a purpose of increasing racial diversity are under threat also, even if they do not directly use race. And I'll stop there.
Thank you. Let's hear now from Professor Michael Dorf at Cornell University, who's the Robert S. Stevens Professor of Law.
Thanks so much for including me. I'll say a few things in response to your initial questions, and I'm going to overlap a little bit with what we've just heard, but hopefully take it in a slightly different direction. So one of the questions was about options for Jesuit universities. And I think any religiously affiliated private university, and of course, if they're religiously affiliated, they're private universities, should explore the option of using the Religious Freedom Restoration Act to get an exception from Title VI's prohibition here, right? That is to say, Harvard was evaluated nominally under Title VI, even though the court applied the same equal protection standard. Justice Gorsuch in his concurrence yesterday said he thought that maybe there was some space between Title VI and the Equal Protection Clause. The majority didn't address that because they said it wasn't presented, and they've treated them as equivalent since Bakke. But in any event, the only whatever the gap or not gap there is between Title VI and equal protection as a matter of the substantive standard, it is undoubtedly the case that the only reason any of this applies to private colleges and universities is in virtue of Title VI, which is a statute. And as a statute, it is subject to RFRA, which grants exceptions. Now, you might say, well, is it part of Catholic or Jesuit teaching that you have to have a racially diverse class? Well, that's not the question. Under RFRA, people and entities have been granted exceptions based on being motivated by religion. So if part of the social justice mission of a Jesuit university is to promote racial justice, it strikes me that there is at least a prima facie plausible argument that there is for a RFRA exception. Okay, what about everybody else? And I should say even everybody else, lots of colleges and universities that we don't think of as religious have some religious doctrine at their founding. You know, they might not be overtly religious, but they have something. So that's a lot. With respect to, you know, apart from religion, in her dissent in the Gratz case, this is the University of Michigan case, the college case, not the law school case. You'll recall that in the Gratz case, there was a split decision in the Michigan cases. The Supreme Court upheld the law schools program in the Grutter case, but struck down the undergraduate admissions program in the Gratz case, saying it was a de facto quota. One of the arguments that was made by the majority in Gratz was that race-based measures were unnecessary because you could go the Texas percentage plan route. And Justice Ginsburg in her dissent says, well, those aren't race neutral. After all, if a state were to adopt some program for the purpose of disadvantaging a traditionally disadvantaged racial minority, Blacks, Latinos, et cetera, even if they used formally race neutral means, that would be impermissible. Everybody knows that Texas adopted the percentage plans because they wanted to leverage the de facto segregation in the high schools, and it was for the purpose of increasing diversity. If you can't do it for traditional discrimination, you can't do it for remedying discrimination, according to you, the majority. And therefore, she said, this shouldn't count as racially neutral. Now, whether or not Justice Ginsburg was right about that, it's clear from the court's cases in this area that the conservatives reject that. That is, despite claims about symmetry between cases involving discrimination against disadvantaged minorities and affirmative action, the court has never applied symmetry with respect to that piece, the piece we just heard about. That is to say, the use of race-neutral means for a racially inclusive goal. And I think the reason they haven't is because it's not clear what your baseline would be. So when Justice Thomas, in his dissent in Grutter, says, well, Michigan could just use a lottery among minimally qualified applicants, and that would get them more racially diverse student body. He's accepting that that counts as race neutral, even if the goal is to have greater representation. So it's clear that in this area, there are many, many more options available to colleges and universities, so long as they are formally race neutral. So as we heard, one example is just look for people who have been the victims of race discrimination as individuals. Another example we've heard about, right, is I caught some of the last panel, going to test optional, or even as California has done, test blind admissions, right? A lot of the racial gap shows up on the standardized tests, less so on high school rankings. That sort of leverages the de facto segregation again. So that's another thing you can do. Something else I would, urge is, absolutely, send people to California, learn from them. They've had a lot of experience now in figuring out ways of achieving, whether we call it diverse. I realize it's not just what we call it, but in keeping minority students enrolled. And then the final thing I would say is, the Students for Fair Admissions made much of the fact that Harvard could have greater racial diversity without using race expressly if they were to eliminate legacy and donor preferences and alumni legacy, donor, and faculty children preferences in admissions. And that was somewhat disingenuous because they were sort of just using that as a way of getting at Harvard's actual program. But it is nonetheless a good idea that has a lot of justice behind it, right? That is to say, legacy preferences especially lock in past discrimination. Donor preferences are just gross and totally at odds with any kind of notion of what we're trying to do in higher education. Preferences for faculty, kids, as the father of 2 children who are currently in college, neither of whom goes to Cornell, I can give that up too. So I think there's a lot that can be done within the bounds of the law, even as changed by this decision.
Thank you. Let's hear now from Bethany Lee, who's the legal director at the Asian American Legal Defense and Education Fund. Bethany.
Thank you so much. And there's so much to say about yesterday's decision and its egregiousness, but what I'm going to focus on is the perversion and the contortion of invoking the legacy of civil rights law and Brown v. Board that the majority did in such a way that suggests that this was the natural conclusion of that legacy of cases, which is just not true. And this is something that we've seen before, this kind of distortion of narrative in history that is disingenuous and false, because we've seen this in the Asian American context in this particular case. There's been an erasure of the history of solidarity and just cross-racial movement building that Asian Americans have had with other communities of color, whether we're talking about when we first stepped foot in this country, where we began to face discrimination, or during the civil rights movement, where the term Asian American really emerged as a result of the fight that we had for civil rights in collaboration with other communities of color. We've seen this change in the story of what it means to be Asian American in this country, or the story of it at least, because really Asian Americans have benefited from affirmative action. When we look at a campus like Harvard, it's gone from 3% in the 1980s to 20-something% in, I think, for the class of 2026, right? So under this whole affirmative action regime, what we have seen is that Asian Americans have benefited. And it's not just Asian Americans, but all students. And so this idea that Asian Americans now are being pitted against Black students, against other communities of color, and it's affirmative action that's the problem. That is a story and a narrative that actually builds into the story that a white supremacist agenda wants to create. And that's why it's being used, because let's be honest, this case was never about protecting Asian Americans. I'm going to point to a very kind of small thing in the opinion, a seemingly small thing, but actually is actually about something much bigger. If you look at the majority opinion and you look at, for example, Sotomayor's dissent, obviously a lot of differences. One small difference, though, I would point you to is the hyphen that the majority opinion uses between Asian American and the hyphenless Asian American that Sotomayor, for example, uses. Why is that significant? Why am I pointing out this kind of tiny little punctuation problem? Because for many, many years, the hyphen has been used as a way to otherize us, to say that we are not American. And so just even that tiny little punctuation point is, to me, illustrative of how the majority views Asian Americans and really the use of them in this case and our position in society. When someone earlier talked about the triangulation of communities of color versus the way people who are supportive of affirmative action are thinking about and understand the narrative of Asian Americans. Because when we talk about this triangulation of communities of color, it's helpful to that narrative of white supremacy to say that we're the model minority, that Asian Americans are successful, because then we're able to be used to say, well, then there must be something bad that those other communities of color are not doing, right? But then the problem with that, and we're seeing that now, this now playing out in current events, is that where it's useful to use us as the model minority in the affirmative action case, it's also useful to use us as the enemy when we talk about us, this other stereotype of Asian Americans as a perpetual foreigner. So we're either really great, right, and really smart, or we're the enemy of the state, right? And we're seeing that play out right now when we talk about these anti-China policies and how it relate and how our kind of so-called national security imperatives relate to how Asian American populations are being treated. We've seen it in the past. Again, this is just a repeat of history where we have seen how South Asians and Muslims have been treated in the past with post 9/11 policies and surveillance. So there's kind of, it's like where we are used the way we're used in a way that's helpful to this white supremacist agenda. And it's important to counter that, right? And for us, that was very important. The telling of this narrative and a countering of this more unfortunately dominant narrative of the Asian American community as the model, this false narrative of the Asian American community as the model minority and opponents of affirmative action, this important racial justice tool. Countering that narrative was incredibly important in the brief that we submitted. And I mean, to talk a little bit about diversity, diversity is good. I mean, there's and there are real implications about the lack of diversity that could happen as a result of this decision, right? And those practical considerations are about not getting the students into medical schools that we need in order to be responsive to the medical needs in our communities, and specifically communities of color, Black communities, Latino communities, Asian communities that are very different from white communities, right? And we're also talking about getting future leaders into pipelines that if those pipelines aren't diverse, then our leadership and the people who make our decisions like the Supreme Court, do not otherwise end up being reflective of our society. So diversity is important, but also, you know, on the flip side, affirmative action was never only about diversity, right? It's actually about correcting the unjust structures and systems in which white supremacy is baked in. And thinking about what that means is important, and and understanding that history is important, especially when we're talking about higher ed institutions, right? We're talking about that history that we're talking about is a history of slavery, a history of Black codes, a history of Reconstruction, segregation, redlining, all that has led to the types of communities that we live in the United States, that has then created the type of inequitable public school systems that have resulted in the need for affirmative action in our higher education institutions, right? And it's because we have need actual affirmative action to disrupt the status quo in order to ensure that there are opportunities available to communities of color who have been systematically blocked from the resources and institutions that the rest of society has had access to. It's because of that affirmative action has existed. And so to me, that's so important in thinking about the question about how higher education institutions respond, because we should be talking about taking away standardized tests. We should be talking about taking away legacy admissions, but also what kind of environment are we creating for students once they actually get in the door, right? I can remember my first 2 weeks in law school, actually. I remember sitting in a class where a white professor who meant nothing of it, but a white professor used the Chinese accent to illustrate his point. And, I came from a history of student activism. I understood, but for me, sitting in this institution that I, had just become part of and was still predominantly white, I had no idea what to do. And, earlier, I think someone was talking a little bit about how do students who have been marginalized feel in these types of institutions, sometimes really powerless. And what does it take to build them back up? I mean, I don't think I fully understood what it meant, or fully understood what it meant to feel like I belonged, until in my second year. I remember finding Professor Mari Matsuda, who, as many of you know, is one of the leading critical race theorists in this country. And it was because of her that as a law student, I felt myself being built back up and feeling like this was a place and this was something that I could actually do, right? And that is so important when we talk about not only making sure we do the right recruitment, but also creating the right environment for students, where it feels like not only that we feel welcome, but where we can actually thrive and actually take seats of power, right? And become leaders in our own right. And I think I would be remiss to talk about next steps without also talking about the K-12 experience, because while we're here kind of talking about the higher education space, it's really the K-12 experience in some sense that we're remedying, right? When we talk about policies like affirmative action. And so to me, in that space, when we talk about public education, yes, it was about segregation, but it's never been only about segregation, right? It's actually about the resources that we are willing to put in to our public institutions to ensure that there are equal and equitable outcomes. And I've seen this, for example, in kind of like communities of color feeling like there are tiny slices of the pie that they only get to take when we talk about these specialized school cases. Earlier, the Thomas Jefferson school case was referenced, and I represent a multiracial coalition of families, students, and organizations in the equivalent case pending before the First Circuit regarding Boston Latin School. And there's such fervor when we talk about these schools, right? And unfortunately, in that particular case, the Asian American community is being used in the same way when we talk about this triangulation of communities of color. But my bigger question is ultimately why is it that one case, and why is it these magnet schools where we're focusing all of our energies and resources, right? It should not be that one piece of the pie that everyone has access to, and higher education institutions have a moral imperative in thinking through what that means, given that the communities that they are also inhabiting in. Thank you.
Thanks, Bethany, for invoking Mari Matsuda, and also for using terminology like systems and systemic that an increasing number of states won't let you use in K through 12 and even in universities. And so we turn now to Erica Wilson, who's at the University of North Carolina from the front lines of yesterday's decisions, and she is a number of things. She's the Wade Edwards Distinguished Scholar, the Thomas Willis Lambeth Distinguished Chair in Public Policy, and she's the Director of the Critical Race Lawyering Civil Rights Clinic, another phrase that you can't invoke, nor principles in some states. So Erica, welcome.
Thank you for having me. I'm going to actually start on a little bit of a somber note, but hopefully towards the end of my remarks, leave us with a little bit more optimism, or at least a proposed path forward. So I have two deeply personal connections to this. First, as Dean Bender said, I'm actually teaching at the University of North Carolina, and so we've been in the thick of this litigation for some time now. But maybe even more personally than that, I actually attended UCLA for law school. I graduated in 2003, so I enrolled literally the year after they implemented the admissions policy after Prop 209 banned race-conscious admissions. And so the experience being a Black student at UCLA in a post-affirmative action world was one that I would not want to replicate for other students of color. And so the somber, I guess, note I wanted to begin with is I know people have tracked the language carefully about, let's see what has happened in places like California and Texas. And what has happened using the status quo with the admissions policy has not been good. So for example, when I was a student at UCLA, I had a class of 320 students. There were only 4 Black students in my class. And these were the numbers after UCLA actually did attempt to use class as a proxy for race to try and give a little bit more weight to lower socioeconomic status. And so the point I want to begin with is that the general admission system as it stands now has a number of inherent biases that likely cannot be overcome through race-neutral mechanisms. So I think it's important to begin there. And if people take a look at the actually amicus brief that the UC school submitted in the UNC Harvard case, they basically say the same thing, detailing all of the efforts they made to try and implement race-neutral mechanisms to achieve diversity, and acknowledge that while they've had some gains moving to a more holistic admissions process, their numbers still remain abysmal at the highly selective universities. So UC Berkeley, the percentage of Black students is only 2%. UCLA, it hovers somewhere around 4-5%, which is drastically underrepresentative of those populations in the state of California. So I open with that vignette with an encouragement actually for us to think about this as a moment to be more transformative in the admissions process overall, and to rid ourselves of the notion that we will be able to rely on race-neutral proxies while using the exact same admissions system in order to achieve diversity. The important, I think, thing to note about racial diversity as the end goal of affirmative action, I think, as Professor Rothmeyer said, it was foolhardy from the beginning. The idea that doctrinally racial diversity would support the use of race-conscious admissions was always on slippery ground. I suggest at schools like UNC in particular that have a sordid history of past discrimination against people of color, that the goal not be racial diversity, but that the goal be twofold. First, preventing the resegregation of higher education, and second, remedying past discrimination. I think one of the great tragedies of the affirmative action litigation, beginning with Bakke, is that the litigation always started from the perspective of an applicant, white applicant in particular, suing, claiming that they were excluded from a university under a reverse discrimination theory. And there's never been affirmative litigation actually pushing universities with a history of past discrimination to remedy that past discrimination. Universities like UNC, I think Justice Sotomayor and Justice Jackson both documented well the past history of discrimination that UNC had, in particular, the fact that well into the 80s, UNC was still resisting integration. So I think one step universities like UNC with the past history of discrimination could reasonably take is to start taking seriously the obligation to document their past history of exclusion and to develop a holistic admission policy that seeks to overcome their past history of discrimination, using things that measures that I think may closely approximate, help us to attract people who may have been the descendants of people who, the descendants of the past legacy of discrimination. So for example, in North Carolina, there's a case called Leandro, where the North Carolina Supreme Court has held that the state has not fulfilled its obligation to provide an adequate education for students in K through 12. When you break down the funding disparities in that Leandro case, Black and Brown communities in particular are hit the hardest. Resources flow to them the least, I will say. And so a school like UNC could take the measure to look at particular counties or areas, places that were identified in cases like Leandro, and to award additional consideration to students who come from those areas. The university could also take a hard look at its current admissions policy and to see where some of the factors, whether it's zip code or legacy admissions, benefits people who would have benefited from the prior history of discrimination and exclusion. If you think about UNC resisting integration up through the late 70s, early 80s, that means that there are certainly going to be Black and Brown students who whose parents, grandparents were excluded. So someone being able to tell a story like that would also be one way for the university to try and remedy its history of past discrimination. I think to Bethany's point as well about the environment that is left at these schools, that preventing the resegregation of higher education is another goal that the university should trumpet widely. One of the challenges certainly that universities will face is recruiting students of color to an environment where there's not a critical mass of students of color. Getting students to want to attend a school that has a 2%, 1% of Black and Brown students will certainly be a challenge. So in line with preventing the resegregation of education, it's incumbent upon these universities to revamp their admissions policies, to stand in the truth about the ways in which the current admissions policies actually severely disadvantage students of color. So that's my somber and positive note that I wanted to end on. I think there's a path for it, but I think that path requires universities to take seriously the obligation to prevent the resegregation of higher education, and particularly state schools with a past history of discrimination and exclusion, to document that well, and to reformulate their admissions policies in ways that seek to overcome that past history. Thank you.
And thank you. You mentioned laying a path, and you did that in your Harvard Law Review, Monopolizing Whiteness, that the dissent cited yesterday. And so we're honored and privileged to have you with us today. And so now we hear from my colleague, Andy Siegel, who's a William Oatman Professor of Teaching Excellence. And Andy is enjoying his last day as Vice Dean of Academic Affairs for so many years. So congratulations on the newfound time you will have to refocus on whatever the Supreme Court seems to be doing.
Thank you, Steve. It is certainly not the way I expected to spend my last day, but I'm thrilled to be here with everybody. I'm honored to be on the panel with so many esteemed folks. In some ways, it's hard to go last after a dozen of you have spoken. I've spent the whole time furiously scratching off things that I wanted to bring up or say because everybody has hit on so much. I'm tempted as my last act as a member of the administration to give thanks to you all and let everybody have lunch. But I do want to say a few things. I'll keep it short. The first thing that I want to do, I think, is to put a frame around a lot of what we've been talking about in terms of the various things that we know schools are going to do, that we're encouraging schools to do. And it's a wonderful list that we've put together here and that others have put together. I think sometimes the frame that gets built naturally, and certainly the frame that the conservatives and the court would like us to have, is we're talking about ways of resisting or avoiding the court's decision or fighting against where the law has gone. And I don't want that to be the frame. I mean, I'll read you something in a second that kind of brought this home for me. But as I've been reflecting on what's been going on in this space for the last 45 years, I kind of bring a legal history or law and society frame to it. And I think we need to distinguish between the law in the books and the law on the ground. I mean, in a fundamental way, over the last 45 years, there have been two distinct constitutional cultures out there, two distinct constitutional visions. People who think that the use of diversity, the use of affirmative action, the focus on remediating racial harms is per se unconstitutional, not part of our constitutional order. And people who think that it fundamentally is part of our constitutional order, in fact, is probably required by our constitutional order. And the polarization between those positions has only grown. And one thing I realized in thinking about this yesterday was there are 237 pages. And on that fundamental question, I think the grand total of number of people who were convinced or changed their mind in terms of which constitutional culture they belong in is probably zero, right? Nobody changed their mind on that fundamental question. The same number of people think that the Constitution requires these kinds of measures as yesterday, and the same number of people think that it prohibits it. So if we're talking in that term, in terms of on the ground, people fighting, one group of people fighting to resolve these harms, to respect diversity, to create level playing fields, to create inclusion, to remedy systematic past discrimination, and a group of people fighting very much to prevent schools from doing that. It's a question of strategically, tactically, empirically, what has been succeeding, what has failed. And in some ways, not that much changes because of this ruling, right? What changes is the moves that people make, but both sides are still playing and fighting and have a lot of tools. The fact of the matter is, for 45 years, because the Supreme Court gave half a loaf, we've been using the same tools. We've been talking about diversity rather than other ends. We've been using particular kinds of mechanisms. We've been fighting some battles, not fighting other battles that we've talked about today versus legacy admissions and things like that. And now it changes. For better or for worse, as an administrator, and I'm sure you guys all got them too, I got dozens of statements today from schools saying what they're going to do. And one of them, almost at random, really hit home about this point. One dean who I respect a lot says, "We recognize, of course, that as the law changes, universities will need to make changes in turn. But complying with the law does not mean that we will abandon our values, even though we may have to adapt our ways of parsing these commitments. While today's ruling will undoubtedly present limitations and challenges, I'm confident that we will find a way not only to preserve, but to further enhance the vibrant community that has become a hallmark of this school." Again, think about that language. It's about strategy. It's about making moves in response to moves that others are making, trying to reach results on the ground. So I do want to keep that perspective here, that the tactics that we're talking about today, I think that they're great. I think some will work and some won't work. And then empirically, we have to throw everything at the wall to see what combinations achieve the best results. But we shouldn't feel like we're writing and working and strategizing against the law. We're fighting for a vision of the law that is well represented and that still has lots of tools at its disposal. So that's one point. A second point is related to the issue that Mike Dorff and Vinay talked about, which is ultimately what will be allowed. How much is open right now in terms of the existing doctrine, in terms of which of these tactics will be allowed, what circumstances, what ends. I found it very interesting that Vinay took a very pessimistic view of what's going to happen with regards to nominally race-neutral measures that that are designed for the purpose of creating and enhancing diversity, while Mike Dorff took a more optimistic view. And I think that both of them are expressing views that are well grounded in what the conservative justices have written over the last 25 years. I mean, for example, in Parents Involved, the Seattle Schools case, Justice Kennedy said basically that the constitutional violation was in large measure that they didn't use these kinds of measures, that they didn't go out and draw attendance zones and hire teachers and design magnet schools with the goal of in nominally race neutral but racially motivated ways. Well, clearly, I think that there's a lot to be seen in the opinions of Justice Thomas and Justice Alito. In fact, in some of the ways they're pushing things into other areas. They have a couple of dissents from denials of cert on other race cases today that kind of forward their vision, that they're gunning for these kinds of measures. And the truth of the matter is that it will come down to, again, some of the justices who aren't on the record here. Is Chief Justice Roberts, is Justice Kavanaugh going to be going down the Justice Kennedy route here, or the Justice Thomas and Justice Alito route? So those, in terms of predicting the battles and readying the litigation strategies and readying the PR strategies, I think those are the big cases. I think that Vinay and Mike are really right to have identified them. My final point that I wanted to make is I was going to make a point very similar to the expressive harms point that Professor Evans made in the first panel, that even if the most optimistic results come out of this panel, come out of the world that this panel anticipates, and that on the ground, numbers of students don't change very much or even improve in the long run, and college admissions improves in the long run and becomes more equitable in the long run. Certainly, there are harms that come simply from the existence of these opinions, the things that were said, the distortions that were written in the name of the court and in the name of the Constitution. So I just want to say that again, with the one additional little piece, that one of the things that I think is so harmful about the opinion is the tone of defeat. Chief Justice Roberts tries to sound like Justice Alito sounded last year in Dobbs, tries to sound triumphant, tries to sound like he's resuscitating the Constitution, that this is what it always should have been, and that it's great that we're getting there. So many parts of the opinion that he can't pull that off. So many parts of the opinion he says, we're giving up. He's saying that this would take too long. It's too hard to measure. You're telling us that these problems persist, and we're not arguing that these problems persist. but the court's out of time, it's out of energy, it's out of ideas. And that notion of giving up, I think, is at the heart of the expressive harms of the opinion. And it's that attitude of despair and defeat that's one of the things I think we need to battle against in the coming months and years and decades. So I think that I, like everybody else, have plenty more to say, but I'm going to leave it there. If we have any more time, Steve, give it to the questions.
So we're almost out of time, but we're not out of ideas. And thank you, Andy, who also taught before Seattle at the other Carolina, South Carolina, and clerk for Justice Stevens. And so one of the questions that we didn't have time to consider but fortunately our panelists, particularly Angelique and Michael and Bethany, just addressed was what are sort of the student admission preferences that are baked into university admissions that are really proxies for white admission. And several were talked about, including legacy and donor preferences and standardized testing, and others. And so instead, I'm going to frame a question that derives from a number of audience questions, and it addresses really how far the decision, the opinions yesterday reached, and both within admissions but beyond. What are the implications for historically Black colleges and universities? What are the implications for Hispanic and Native serving institutions? Particularly a lot of questions around race-based scholarships, even law review selection, and race consciousness and those decisions. And then from a researcher scholar, a really important question about data collection, both sort of in the micro, individually in applications to universities, with applicants individually being asked about or not allowed to be asked about their race, but also data collection in the aftermath, the collective, for the benefit of knowing what's going on and for researchers and other programs. So I'll invite any of our panelists to succinctly address that in our final few minutes. Any volunteers? Mike?
Yeah, I'll take a crack at one piece of it. So I have a very good friend from elementary school through high school who's a lawyer for he does compliance for a very big company. And he was telling me literally last night that in the compliance world, so this is companies, right? It's not education, but they're affected by this. The government requires them to collect and keep track of their utilization of people of various categories to ensure essentially that they're not engaging in disparate impact discrimination, or of course it could also be disparate treatment discrimination, but at the very least disparate impact discrimination. And of course, one of the things that Justice Sotomayor points out in her dissent is that the majority chides Harvard and UNC for collecting data that are absolutely necessary just to see whether you're engaged in discrimination. So this put me in mind of Justice Scalia's absurd concurrence in Ricci against DeStefano a number of years ago, in which he said that disparate impact prohibition might itself be unconstitutional because it induces firms to engage in what he called quotas, but it even actually would be any sort of preferences. So I think there is going to be some impact in the Title VII landscape, which would be huge because that's employment for millions of people. But I think that's yet to be worked out.
Thanks, Daria. You have the last word.
I just want to emphasize that the majority's opinion did not kill formally race-conscious admissions. And so it would be incongruous to read an opinion that by design, even though through misrepresenting precedent, was meant to at least facially keep the possibility of race-conscious admissions alive, to require schools to stop collecting information on racial identity. It's what you do with it and what kind of program you design and whether or not you can thread the needle and jump the bar that's now potentially impossible to jump. But I don't read the decision as preventing the collection of information at all.
Thank you. And so I want to thank our panelists and thank our dean, in particular, Tony Varona, for his vision in conceiving and pulling together this very rapid response. And some of you have asked about recordings, which will be made available broadly and publicly about this event. And I want to give a special shout out to all of those doing pipeline work that's more critically important than ever, including our own university that's part of an LSAC Heritage Plus program for Central Washington students of color. And we also have a Loyola high school pipeline program. And that pipeline work to deepen the pool is both lawful and essential, in my and our opinion. And so everybody be safe and take care and hang on, because we have closing remarks from my colleague who's our university vice dean for diversity and inclusion, Natasha Martin. Natasha.
Thank you, Steve. First, I want to thank all of our panelists for their insights, and to the moderators, including you, Steve, for facilitating such a rich discussion. Thank you also to our law school's dean, Tony Varona, for leading the charge to create this critical opportunity for us to gather today. And of course, thank you to our tireless staff for making all the necessary things happen so this could all go so rapidly executed as it has. So reflecting on what we have heard very briefly, today leaves all of us, I think, with a lot to process and for which to account. What the court did yesterday was sweeping in its scope and in its ambition. And today we have heard a lot about the changes ahead, discussions about how policies will change, the way our systems will be modified, and how universities are going to be impacted. Dean Dana Matthew astutely started us out by reminding us that we cannot let popular narratives of the death of affirmative action control our responses. While deeply narrowed, it is left to us to be careful students of the opinion, and as many have heard and pointed out today, creatively respond within the articulated bounds of the law. We also heard from Professor Jeremiah Chin regarding how these cases reflect inconsistencies that animate this court's particular jurisprudential approach through their treatment of doctrines like standing, reliance on statistics, and analysis that is decontextualized. In our second panel, Professor Angelique Davis chronicled how systemically white supremacist systems will remain in application processes unless institutions take the necessary steps of abandoning them. And Professor Harpalani and others forecasted how these cases might be but the wedge into an expansive rejection of race consciousness. These are all important considerations as we make our way forward in this new ecosystem, including the impact on the K-12 pipeline and the well-documented inequities in a web of public educational school systems across the country. And I'm so grateful that we got to hear from such strong perspectives today. So as I close, however, I do want to take the opportunity to remind us of what has not changed. We still live in a time of deep inequity. Our country is rooted in it, from stem to stern, from our crops and land to our buildings and our institutions, from our schools to our businesses, and from our government to our capitalist economy. All of it is built on a foundation of racialized exploitation. What has not changed is the very real and systemic result of enslavement, violence, and discrimination. So while we have focused today on what is changing in light of yesterday's opinion, I want us to remember that regardless of what the court does, and how the law continues to unfold, this reality I am describing has not changed at all. As Justice Ketanji Brown Jackson stated in her dissent, and I quote, "Deeming race irrelevant in law does not make it so in life," end quote. I appreciate that we all live this truth, this reality, differently as individuals. And depending on our lived experiences and your perspective, you might have come to yesterday's case and today's panel with a particular view of what these cases mean. What I hope is true is that while we may disagree on whether the court's decision was justified, whether it was rigorous enough, or whether it was for ill or good, that we agree on one thing with respect to these cases, and that is this. As we move forward, it is our duty and our responsibility to create access to educational environments and opportunities that invite students into an ecosystem where they feel they can belong, learn, and thrive, and contribute. And we must take seriously Professor Erica Wilson's cautionary note that perceptions of diversity on campus can impact that very sense of belonging and integration into a learning environment. The way forward in achieving that goal may have been complicated by these cases, but the necessity for that common purpose for our students should push us to be creative, innovative, and thoughtful on their behalf. In Professor Leah Epperson's words, the promise of Brown has been distorted by these cases. Returning clarity to that promise, the truth that diverse learning environments are academically excellent environments, will require steadfast reliance on and the careful collection of data, the implementation of high impact and effective practices, and the abandonment of counterproductive ones. And it will require our solidarity as educators, as well as courageous institutional leadership, especially from those with financial and reputational means. My closing hope is that our disagreements do not distract. Instead, we must commit to deepening our commitment to creating the atmospheric conditions that create opportunities for and allow the pursuit of an educational environment where students thrive and belong. Stated differently, my hope is that we don't just clarify Brown, the promise of Brown, but that we exceed it. Thank you very much.